Okay, welcome to the panel on mind reading. We've got an hour for the panel. We're acutely aware that we're also the only thing standing between you and lunch, so we're going to try to stay on time. Because you've got those wonderful speaker bios, I'm going to keep I am Dan Sackler, by the way, from the Department of Psychology at Harvard University, and I'm going to keep all the introductions as short as the one that I just did for myself, so that we can use maximal time for the speakers. We're going to have 15-minute talks followed by 5 minutes of questions. One thing we know that doesn't lie is my iPhone timer, so I'm going to use that to keep all of our speakers honest. And I think we're going to hear a nice fleshing out of some of the issues that we've heard raised in the interesting talks earlier this morning. To get us going, we have Dr. Stephen Lakin from CFOS Corporation, who's been doing a lot of work on fMRI of lie detection and its possible application in court.
Great. Thank you very much, Dan. Thank you for the National Academy and the Royal Society for inviting me. I very much appreciate the invitation and think it's great that you extend the invitation to commercial companies. I've been asked to present two things. One is an overview on fMRI and lie detection, and the second one is some of the cases that we've worked on and some examples of those cases. The first thing that one should be aware of is that lie detection, there are a lot of regulations around lie detection. The first is that most states have about half of the states have some regulation with using lie detection for some form. Many of those are polygraph exclusive, which means you can't use any other lie detection technologies. Some are written very broadly to say any lie detection. The U.S. military, the Secretary of Defense bans any technology except polygraph, and there's a presidential ban in military courts, as you know, in Sheffer versus U.S. Against the use of anything but polygraph. And part of that was because of the use of voice stress analysis that was going. We have an Employee Polygraph Protection Act, which prevents people from using polygraph for pre-employment screening or as a condition of continued employment. And then, as you know, there's court, there's a Frye court, Daubert court, and then there's mixtures of both. The first peer-reviewed publication in fMRI lie detection was in 2001, and since then we're right over 40 right now. I haven't put 2011 in there, I just have complete years on here. And we have 40 publications about using fMRI in some form of lie detection. Cumulatively, we're well over 500 subjects, and what do we learn from these studies? Virtually all the studies show that when a person's lying, there's more brain activation than when they're telling the truth. That's across all of those 40 studies. It's irregardless of whether or not age, race, ethnicity, the type of lie, motivation, and instructions, lying activates more parts of the brain and there's more brain activity. In some of those studies, there was some activation on truth-telling. We haven't seen activation on truth-telling, but one of the things about the statistical maps that are created is depending on how you do those thresholds, you may have some activation. Some of those studies do have some activation on truth-telling. When we're doing lie detection, our company, we're looking for basically the presence of more activity when a person's answering questions as if they did do something versus when they didn't do something. And I believe that there are some consistencies in the brain regions that are activated, and I'll show you a peer-reviewed study about that. Generally, the regions that are activated are the anterior cingulate and the prefrontal cortex. What are the things that we don't know? And again, this is my list, and I'm trying to provide a background for this and bring up the other things that people have talked about. Countermeasures. There's a lot of discussion about countermeasures that people might be able to use, both physical countermeasures. These might be physical or mental countermeasures. Physical would be things that they actually move their body. Mental will be thinking about something, using math problems. That people have said and stated, and neuroscientists state this as a fact, that if you use countermeasures, you can beat the test. But I haven't seen any study yet that actually definitively proves that that can occur. Facts versus beliefs. And this will be a good, the next talk is talking about memory, and I think there's a lot of interesting things about some of the things about facts versus beliefs that can rise here, which is if someone tells themselves a lie long enough and they believe that lie, is that a lie at that point? The way we define a lie is the conscientious act to con or deceive. Well, if someone believes their lie, they've convinced themselves of a lie, by definition, that's not a lie anymore. And so, therefore, it's going to show up as a truth. That's our belief. We don't have any data to show that, and I don't think anybody in the scientific community has shown that. It's not the factual statements, it's what a person believes. It's what's in their mind. There's a lot of discussion about lab settings versus real-world settings. I continue to hear people talk about, well, all these lie detection studies are done on 22-year-olds. That's factually incorrect. The studies that we do are on people between the ages of 18 to 50. We don't have data on people over 50. So I should say, how it works on those people over 50, we don't know. But the results of people at 18 years old look like the results of people at 50. Giving people an opportunity to lie, or telling them to lie, or paying them to lie in a lab setting may be different than a real-world setting. But there are some fallacies about that, I believe, which are people say, well, you're going to incarcerate someone and put them in jail. No, if someone has an MRI test, they're not going to jail. If they're there voluntarily, they're not going to jail after they have their test done. But there could be some differences, and we don't know what those differences are. We don't really know what these pathways are doing. We don't have consistent pathways across all of the studies, and the pathways may be activated for other reasons. And from a scientific point of view, scientists want to know, tell me exactly what this part of the brain is doing, and is it activated all the time? If it's not activated all the time, then I'm concerned that the stuff doesn't work. Well, that's a concern, but that doesn't necessarily, it's not a requirement for admissibility. And finally, we don't know how our commercial technologies fare in other people's hands. When we do our tests, we do everything blind, which means that when we do the analysis in our laboratory, we send it out to another person, Andy Kozel at the University of Texas. He does all the same analysis, and we get all the same results. But we do that, or if he does a study, we do the analysis. We do that to keep it blind, so we don't actually know what the person's lying about. But today, no academic has decided to actually take our technologies and apply it into a laboratory setting, or to provide data to us where we can actually provide our testing in their setting to determine how it works in another setting. In 2009, Chris looked at 13 of the papers that I showed, and he showed this brain, and he basically was doing something called a meta-analysis. They put all the data in, take all the brain coordinates, and then from all those brain coordinates, you can basically get the common regions of the brain that are activated. Now, we've talked a lot about bias, and you clearly know my bias. I'm a commercial company. I want to make money. The company has to exist to make money. But there's a lot of bias in the academic community, too. And so I put this up because I say one can look at this, and maybe I should explain this a little bit. Each one of these dots here is a brain region that's activated in one of the lie detection studies. And this one, it's all on the lie regions of the brain that are activated on lies over truths. And what you see here on the orange and yellow areas are the common brain regions that are activated across all those studies. And so you see some ventrolateral, you see some medial frontal, you see some anterior cingulate over here. But again, depending on which argument you're on, I guess if you're on the defense or the prosecution side, you could make this argument to say, look, there's very little consistency. On the other side, you can say, look, there's very high consistency because look at the L values that are statistically significant. Just a little bit about the company. I founded it in 2004. I'm going to go to the second part, which is about some of our commercial testing right now. In 2005, we published a paper on 60 people. And the first group of people we showed we were 93% accurate. We trained an algorithm on at the individual level to show how accurate we were. We applied that algorithm on a group of 30 individuals. We were 90% accurate. We wanted to get to 95% accuracy. It took us about 3 years to do that. We eventually achieved 95% accuracy. Along the way, we dropped our accuracy when we changed some of the testing methodologies, and all those are published. In 2008, we went commercial. We had to have as I said, in Massachusetts, we have to have a license to offer lie detection, so we do have a Mass license. We're a private investigation service. And when I started going out and started offering this to lawyers, we started offering DNA evidence work because they wanted DNA evidence work. And I'll come back to that in a second. Our clients, about 20% of our clients are in some sort of personal situation. You would think about these as the fidelity cases. Many of these, they don't care whether they're going to, they don't care whether these are going to court. About 2/3 of the cases are cases that are going to some, that are in some legal proceedings. Some have already had a court case and there wasn't a favorable outcome. Sometimes they want to introduce it before court, and we get a majority of these are civil situations. I would say that of the 70% that are civil, Most of those are actually in some sort of divorce situation where some spouse is accusing the other spouse of molesting the children. And it's a very difficult thing, I'm sure, for the judges to deal with, which is there's allegations of abuse. What do you do in terms of custody? In many situations, what happens is the courts just say, look, I don't care whether there's anything here. I'm just going to, take away custody from the father, and maybe I'll let the father see the child, supervised. Maybe I won't. And so these dads are kind of in tough situations because there's no allegations, there's no evidence whatsoever. There's allegations, but there's no evidence, and there's really nothing that they can do. The other issue about this is that because it's family law court, these things are kind of sealed, and so if they appeal them, then it becomes public knowledge that mom accused dad of molesting their child, which a lot of these guys don't want it to be public knowledge that, there's these allegations that have been made. And we also do some habeas stuff, and I'll talk more about that toward the end. There are some court cases. Unfortunately, all these are kind of percolating in some ways, so I can't talk much about them. So if I'm circumspect with your questions, I apologize in advance for that. In 2008, we went to a case, Freeburger, and I'll talk more about that. I was in South Carolina. 2010, Wilson versus Core Staff. 2010, Wilson versus Core Staff was a sexual harassment case. The judge didn't even hear that because it was a Fry court in New York, and he said the technology is not generally accepted. And in 2010, there's a 30-some-odd page opinion written by a magistrate judge in U.S. v. Semra about a guy who was trying to show that he didn't do what he was accused of doing. In the last few minutes, I'll show you some examples of testing. One of the things that I think is really good in these situations is there's a lot of discussion and debate, and there's some things that we do or don't do because of a lot of the discussion and debate. And one of those is that we don't typically put in any of the pictures in there, and part of that is because of this, whether there's bias or not. And it came out from the discussions that was going on at one of these conferences. But I'll show you the pictures because everybody wants to see pictures. In this case, Ted and Frank hated each other. They both put a restraining order against each other. Frank went in and filed a police report that said he was sitting at a stop sign. Ted drove up, started yelling and screaming at him, blah, blah, blah. Ted said he wasn't doing that. Ted had contemporaneous phone records at the time and a witness that said that he wasn't there when he was. And so this is Ted's images here stating that he violated his restraining order. He did all those things that I said that he did. This is him saying that he didn't violate his restraining order. Again, remember, there's more activation when a person's lying than when telling the truth, and that's consistent across all those 40 studies. So you can see here clearly the red and orange indicates more brain activation. Part of the reason we don't put these things up is we don't look at these brain maps. Everything's done and coded by a computer, and it's really a computer that comes out with a response. So it's not as if I use these images to make a professional opinion about what the person was saying. This was admitted in a court in early 2008, but the judge didn't, she talked about it, but it wasn't part of her opinion. The person had a restricted license, and because of multiple DUIs, they said they hadn't drank in 4 years. They were trying to go to the court to get basically 2 more hours because the person could drive to and from his work. And so all I was trying to do is show the court that he'd been a good citizen, he hadn't drank, and he was submitting this as evidence, and he was trying to appeal his ruling. The judge said that she couldn't do anything about it because it was really about whether or not the lower court did everything appropriately. This is Ted basically saying he didn't drink. He has drank in the last 4 years. This is him saying he did not drink. That's the first scan. Second scan, he was scanned 3 times. This is the third scan. I think this explains why we actually don't get into the issue of whether or not we look at these things and make a determination. Because if you look at these 2 scans here, I certainly would say that he's lying on this one over here. But the computer said he was lying on this one. So the computer consistently said on all 3 of those scans that he was lying when he said he has drank in the last 3 years. Finally, in the last case, this is the Freeburger case. I did present the back in 2008. I did submit this data, so I can show you this data. But basically, this guy was convicted of it was a cold case. 40 years later, he's convicted. At the time, under the ballistics, 8 of the 9 examiners could not conclude this inconclusive, which is a huge problem because jurors don't understand. They think that it means the forensic person that looked at it is too stupid to understand what the evidence is. But 8 of the 9 people said they couldn't conclude. They found one examiner who was fired by the police force in Missouri, and what he said is exclusion of all others, that the gun that the bullet came from the gun. As it turns out, the prosecution, and I'm sure Barry Scheck will talk about this, the prosecution sent the gun down to the FBI. The FBI said, no way, this is not the gun, but the prosecution never turned that over to the defense. Okay, so he comes to us for post-conviction relief. The judge actually releases him to get out of jail. We scan him in South Carolina. This is basically this is his brain image admitting that he murdered the person. This is the person admitting, or denying that he murdered the person. So finally, I'd just like to leave this with this. We do a lot of DNA testing. In fact, our DNA testing has grown about tenfold over the last year. And what we're interested in doing is taking some of these people who are coming to us. We do a lot of pro bono stuff with people who are saying that they're innocent. When there's maybe DNA forensic evidence that exists, we can look at the DNA evidence. We can analyze the DNA evidence, and we can determine whether or not that there actually is evidence there that would exonerate this person, or they should get a new trial by that. And part of that is nice because it allows us to potentially go back to some of these clients and say that maybe here would be a good candidate for a real-world test. Our issue is that if we do that in active cases, we have a whole issue of discovery. And finally, I'd like to say that anybody that has an idea on what type of testing can be done or what we can do, I'm certainly open for that. We make all of our data available. We're happy to work with any academic or any commercial academic collaboration. We want to do that. We want to do the validation studies. And we really do take a look at those things that the court says, and then we'll modify and change our testing procedures because of the good feedback that we're getting from the courts. Thank you very much.
Got time for questions for Dr. Lakin?
I'm not certain what the use of a system is that comes with truth-telling. A, when someone is telling the truth, and B, when someone simply believes he's telling the truth, even if he's not.
I think that's a good question, and that's something that we're asked that in a court, and I guess that's really up to the jury to decide. That kind of goes to the probative value of the evidence. Yes.
So it's often noted that it's very difficult to assess fMRI lie detection in real-world settings. And I'm wondering whether, given you have a company out there and I don't know how many clients you've sort of had come through and worked with, but you might be in a unique position to sort of say something about sensitivity, specificity. Have you gone back, and so you showed us a few case studies, have you gone back and looked at all of the clients that you've brought in? And for those cases, those clients where there was separate, independent data entered in some case that is unambiguous as to whether or not about the facts in the case, have you assessed the sensitivity and specificity of your method in those real-world cases where you know what truth is?
I would say that the challenge is that the people who are coming to us are at us because there isn't other evidence out there that can help them out. So they're in cases and situations where, the ballistics. Okay, so you've gone to 8 ballistics examiners. It was introduced at the time. Do you believe the ballistics? Do you believe the one guy?
So you're saying those data don't exist?
I'm saying that there's very few cases. I mean, the handful of cases that we have, but again, they're anecdotal, handful of cases.
One here and then one back there.
I'm sorry, I'm not familiar with that case, but it seems to me such a classic, great case in the criminal law. So can you answer my question first, whether were you allowed to present your lie detection findings in that case with the 40-year-old cold case that had the ballistics? You were?
Yeah, it was so this is the challenge. It was a PCR hearing. As you know, PCR hearings, post-conviction relief, there's a lot more leniency that the judge can do to decide what evidence he allows in to look at that. That happened almost 2 years ago, and the judge just closed the case about 2 months ago. So the judge hasn't written an opinion about that. At the time, the judge said, I'm going to let him testify. I'm going to qualify him. If he seems qualified, I'm going to let his testimony get in. I'm going to let him introduce the stuff, cross-examine in prosecution like it's in, and then I'll make a decision later. So, it's been 2 years, and we're still waiting for an opinion.
I just think it's so interesting, for the scientists in the room that aren't that familiar with how the law works, and I'm sure Barry will get into this when he talks, but you know, the scientists in the room, I'm sure, would be absolutely shocked at the almost complete lack of data underlying ballistics, firearm, and tool mark examination. Obviously, in that case, it sounds like, you know, you also had a blatant Brady violation of people not turning information over, which happens. But interestingly, you know, the courts and judges for decades have allowed in quasi-scientific, you know, in quotes, I always put most forensic evidence in quotations when I use the word science, into court against defendants. And it's also related, I think, to some of the stuff that Susan said. You know, obviously, you know, people can argue about whether fMRI lie detection is ready for prime time or not, but it's just such a great example of, I guess I was interested if that was presented at the trial court level, because I could easily have seen a judge in a Daubert jurisdiction, you know, easily allowing the firearm and tool mark evidence across that very low threshold, and then barring the door to something that had actually a lot more scientific underpinning.
We've got to, unfortunately, unless you have a 10-second response, we've got to...
So I work on a ton of these DNA cases, a lot more than the fMRI cases, and we get to see all the evidence and really plow through it and go through it. And it is absolutely alarming. I will say that the scientists and the academics in the world that don't deal with what actually gets done in the real world, the cops that throw hydrogen peroxide in the knife that ask the EMT to do that, the evidence that gets bagged and nobody documents where the evidence comes from, the ballistics people in the state forensic lab that say that they can exclude any other gun in the whole world at the exclusion of all others. I mean, this is the stuff that gets done every single day in the real world. And, you know, I think it's a separate argument about the fMRI, but there's certainly things that need to be improved with the judicial system.
Okay, thank you.